One of the key reasons why we chose to do this topic is we have a very active HR council here, and actually one of our fellow people on here today, Pam Martinez, is part of, and this was a very important topic that we felt we should cover. So thank you again for joining us, and we hope if you have any questions, please use the question and answer function at the bottom or the chat function. I will be monitoring those throughout the session, and we will get to those at the very end. So without further ado, I can't thank Attorney Shuren enough from Pullman & Conley for joining us this morning. Thank you very much, and take it on over.
Okay, great. Well, thank you for that introduction, and good morning, everyone. Yeah, like was said, my name is Zach Shuren. I'm an attorney with Pullman & Conley. We're a law firm throughout Connecticut, roughly 100 lawyers. We have an active labor and employment practice, but we also address many other areas of the law. So, we're scheduled for an hour and a half today, and I'm not sure if I can talk consistently for an hour and a half. So please, if you guys have questions along the way, that's, if nothing else, it's going to give me a chance to take a breath. So yeah, and I think our hope is to make this, as interactive as possible. And I hope everyone can take away something useful as we move forward. So I mentioned Pullman & Conley. That's my firm. We have an active labor and employment practice. We do traditional labor and employment counseling. I personally handle a lot of collective bargaining union issues. We do employee benefits work. We do immigration work. We kind of run the gamut. So for the last 14 months, like everyone else, our world as labor and employment attorneys has really been kind of flipped on its head. And I think genuinely among Connecticut firms, we have been at the forefront of addressing COVID-19 employment related issues. And what I would recommend is that if you're interested in COVID related topics, we have this page that we've created with a ton of free resources that you can access on. There's 40 or 50 articles on there about COVID related topics that are Connecticut specific. So, please visit this page. I think it's really useful. We also have a very active blog that talks about issues that Connecticut employers face. That's our Working Together blog. That's another good resource if you're looking for kind of hot topics and trying to find free stuff out there that can help you with your HR practices. Lastly, I'll just say we have an education law practice. We represent numerous Connecticut school districts and private schools. And so if you're in that arena, you should visit our education law blog, which has articles on education law issues. Okay, so without further ado, hiring, discipline, and firing. So that's basically cradle to grave, from a employment HR perspective. And as you can imagine, there are a lot of different components within that. So what I've tried to do with this presentation is kind of hit the high notes, talk about general concepts, and really kind of just walk through what you're likely to see out there. Each employment situation is different and individual. So, this is general advice. And if you have a specific situation or a specific employee, attorneys have to look at all the facts. So just kind of have that in the back of your mind. All right, so for general hiring considerations, some of this is pretty obvious and kind of intuitive, but it's, I think, a good idea just to highlight again. So, when you're about to hire someone, when you have the need to hire someone, the starting point really should be for you as an organization to identify exactly what your need is. And again, this is kind of obvious, but what work do you need to have performed? What qualifications should the successful candidate possess? Knowing that before you start interviewing candidates probably makes sense. How much work is needed? Do you need a part-time person, or is this a full-time position? If it's part-time, there's going to be different considerations with things like health insurance and the Affordable Care Act and what your obligations may be to provide coverage. Also, would it make sense for your situation to perhaps have an independent contractor do the work rather than hiring a full-time employee? If you're a small 2-person, 3-person business, having your IT person, own IT person who's an employee probably isn't very cost effective. So exploring what may be out there for someone to serve as an independent contractor may make sense. Also, when does this person need to be available? What kind of shift should they be on? And lastly, this is more important now with COVID, but where will the employee need to work? Is this something that can be done remotely, or is the expectation that the work is going to be done in person or some hybrid of the two? So the flip side of identifying your need is identifying your limitations. So again, these are pretty obvious, pretty intuitive, but I think they're good to lay out. What can you afford? I think having an idea of that at the outset of the hiring process makes sense, because as you get into evaluating candidates, looking at their experience, having a ballpark of what you want to spend for the position is just a good idea. Will the employee be at will, which we're going to talk about what that means a little bit more later, or is the person going to be employed pursuant to an individual contract or a collective bargaining agreement? That's critically important, and that is definitely something that you want to have a firm idea of what you're going to do right at the outset of the hiring process. What benefits are going to be offered? Again, health insurance, if the person is working more than 30 hours a week, then there may be obligations to provide affordable coverage under the Affordable Care Act, Obamacare. If the person is part-time, maybe that doesn't apply, but maybe you want to offer health insurance just as an enticement to get good candidates. Leave entitlements. Is the position going to have vacation leave, personal leave, holidays? How is that going to work? Having an idea, again, of these things before you hire makes sense. Fringe benefits, are you going to provide training to the person? Is there, will the person have a car allowance or a cell phone allowance, things like that? Lastly, supervision. Who is going to supervise the employee, and who will the employee supervise? Okay, so in terms of advertising and posting positions, I think this area of the law for employment law kind of gets overlooked, but it's important to know that the Equal Employment Opportunity Commission, which is the federal agency that governs employment law issues, and the CHRO, which is the Connecticut Commission on Human Rights and Opportunities, they have jurisdiction over not just firings and promotions or discipline, but they also have jurisdiction over the advertisements and postings that employers make to hire candidates. And what also kind of gets overlooked is employment practices that may be neutral on their face, can still be illegal if they disproportionately impact certain members of a protected class. And I'll talk about what that means in a minute. But just know that even if a policy or practice is neutral on its face, it still may be problematic in some cases. Okay, so what do I mean by that? Well, this picture, help wanted, no Irish need apply. That hopefully everyone can recognize that kind of advertise, that's illegal. You cannot discriminate on the basis of someone's ancestry. So again, discriminating on the basis of a protected class status is legal. Protected classes include race, color, religion, sex, gender identity and expression that's specifically recognized under Connecticut state law, sexual orientation, pregnancy, national origin, age. If you're 40 or older, I just turned 40, I'm now considered old and protected under the ADEA, disability or genetic information. Those are all protected classes that are recognized under state and federal discrimination laws. Okay, so, obviously, yeah. Okay, so obviously the Irish need not apply sign, that's a pretty clear example of something that's illegal, but there can also be cases where it's less obvious, but still problematic. So, if you have a job posting that says, our company is seeking recent graduates, that could be a problem because it could tend to discriminate against people who are older. And, not very obvious, but that would tend to filter out older candidates. Same thing with something like, our company is seeking able-bodied men. On the one hand, that discriminates on the basis of sex. On the other hand, that discriminates on the basis of ability. And so if someone is disabled, that tends to filter them out. You want to avoid advertising positions in terms of physical requirements, but you should rather be thinking in terms of the essential functions of a position. So here, you want to think about, you don't want to say that the person needs to be able to stand continuously. You want to factor more, a person needs to be able to service customers at a checkout line. If someone has a disability, maybe they can still perform the work without standing continuously. So I think you want to think in those terms. Another thing to think about, if your hiring or application process is asking job applicants to do things like, submit a picture of themselves, why are you doing that? What's the purpose? To confirm employment or to confirm someone's eligibility for employment down the road after they've been offered employment is one thing, but to do it at the application process generally is going to be problematic because you open yourself up to a claim that you are, discriminating on the basis of race or sex or ability. Same thing with birth certificates. Really think about, do you need to know how old someone is during the application phase of the hiring process? I think 9 times out of 10, you don't. So it's not a good idea to have that or to ask for that. Okay, so interviewing do's and don'ts. And before I move on to that, I don't know if we have any initial questions or not. I can't really see the chat, but no, okay. All right, so some of these points too are kind of obvious, but they're important from a labor and employment law perspective. So Obviously, when you're interviewing candidates, you want to be prepared. You want to have reviewed their information. You want to have sample questions, and what we generally recommend is to have consistent interview questions that you ask all candidates. And the reason we recommend that is because, again, you want to avoid claims from people who are not hired that your interviewing process or your selection process disproportionately or disparately impacted members of certain protected class. You know, if you're only asking men about their ability to perform certain aspects of the job, and you're not asking women, then that lends itself to a claim that you're discriminating. So having consistent interviewing questions makes sense, and also having an evaluation form where you can as objectively as possible rank candidates and record in rough notes what the answer was. Having that kind of documentation from an employment law perspective helps protect your organization from claims about discrimination. Job descriptions, there are a number of reasons why it's important to have accurate, up-to-date job descriptions. But for purposes of the hiring process, it's a good idea to have accurate and up-to-date job descriptions, because having those job descriptions can give you a reference point for asking questions about a candidate's ability to perform the job. And ultimately, that's really what your questions during an interview process should be about. Okay, so what are some questions that you shouldn't ask during an interview? Don't ask job candidates about their salary history. And I'm going to get into why that is in a minute. Don't overpromise or exaggerate opportunities for advancement in your company. There are cases, Connecticut cases, where people claim in lawsuits that during the interview process they were told that that there would be a probationary period, and if they worked out after 6 months they would be elevated to a higher status, higher pay. Be very careful about making those representations during an interview. And if they're not things that you actually want to promise, then you should avoid that. Similarly, don't make references to long-term employment. Absolutely do not say things like, you have a secure future here as long as you show up to do the job. That's a problem, because what if that person is terrible at their job? If you made that representation during the hiring process, potentially they could flip that back on you and claim that they have a contractual entitlement to employment beyond employment at will. Sorry, I'm just looking for questions. If an employee constantly calls out on the same days and gets a doctor's note, how do we address this when it starts affecting our business financially without feeling that we could get sued because they have a doctor's note? So that's a kind of involved question, but what generally with these situations, we're looking at whether or not the employee is protected under the Americans with Disabilities Act. And what we do as attorneys is we usually look at the note very carefully. And if we think it's vague or if it's trying to get around things, we direct the employee to have their physician fill out what's called an ADA certification form, where they outline what exactly their disability is and how it impacts their ability to perform the work. And based on the answers that we get from that form, often you can be, if you need to make a termination decision, you can make the termination decision if the employee is unable to perform the essential functions of their position. Okay, so turning back to the hiring process, I sort of mentioned this before, but the general thing to remember, the general rule of thumb is all you should be interested in is trying to figure out whether or not the person you're interviewing can perform the work. This has particular implications for disabilities because, asking about a person's disabilities is problematic. However, asking whether or not they can perform the essential functions of their position is okay, permissible. I talked about this, but really you should ask yourself, is there any reason why you need to know about someone's protected class status during the interview process? 99 times out of 100, there's not. So you should really be avoiding asking questions about that and maintaining information about those characteristics. So, some other questions that you want to avoid asking. When did you graduate from high school or college? Why does that matter for your job? Generally, it doesn't. So, you should avoid it. Where do you practice religion, or what religion are you? Unless the person wants to work as a priest, that is not something that's going to be relevant. What is your maiden name? Again, why would that be relevant for the position that you're seeking to fill? What is your native language? Where are your parents from? How many children do you have? This last one, what are your childcare arrangements? So this one I think gets a little tricky, and I think employers kind of struggle with this one because very often there can be, young women or young parents who have childcare issues, and it poses a performance issue at times in the workplace. Asking about that, though, during the interview process, we would recommend against that, because all you're evaluating, again, is whether or not the person can perform the functions of the position. If it turns out that the person, you should tell the person, well, this, our job, the schedule is 8 a.m. to 4 p.m. Can you work that schedule? If the person, at that point says, well, no, I have childcare obligations starting at 3:30. That's information that's relevant that you could use to make a determination that the person can't perform the functions of the position. However, getting into the details of exactly what their arrangements are, or who's taking care of their kids, that sort of thing, that just doesn't matter, and it's not something that you should focus on. Again, it's just focusing on, can this person perform the position? Okay, so I kind of talked about this before, but with physical and mental disabilities, again, that's really something that you do not want to delve into really at all. It's what you should be focused on is, can this person perform the job? So a good example of this is, if there's a lifting requirement for your position, or climbing ladders, you can ask the person, you could say, this job, a requirement is we need people to be able to lift 20 pounds and we need them to be able to climb ladders. Can you satisfy these requirements with or without a reasonable accommodation? asking that question is appropriate. It's not appropriate to ask them, do you have osteoporosis? That's not relevant for the hiring decision. The ability to perform the job is what's relevant. So, in some cases, you might be in an interview situation where a person has voluntarily disclosed that they have a disability, or it's very obvious that a person has a disability. They're in a wheelchair, they're blind, something like that. When it's very obvious or the person has voluntarily disclosed their disability, you can go a little bit broader, but again, you don't want to pry into the disability. What you want to know is about their ability to perform the work. So as an example of this, if during the interview process someone says that they have diabetes, and let's say they're applying for a receptionist position, and they tell you that they're going to need to take periodic breaks to take medication during the work, that's okay for you to know that, and it's okay to ask a follow-up question about that, which would be something like, okay, well, how often do you think you would need breaks, and how long would the breaks need to be? That's acceptable. But asking, well, when did you get diagnosed with diabetes? And what has your doctor said about how your diabetes may progress? Is it going to get worse, in the next few months? Something like that. That would be problematic. Again, it's just focused on the ability to perform the job. Just looking at the chat here for questions. If we are requiring in-person staff to be vaccinated for COVID-19, when is the most appropriate time during the hiring process to state that? Inappropriate tasks during an interview? Wow, that's a great question. So I think for something like that, because it's not really because it's really a job requirement, I think you could have that, in your job posting, or it's something that you could disclose during the interview or application process. I don't have any problem with revealing that during the process. If someone says in response, well, I'm immunocompromised, therefore I can't get the vaccine, that kind of takes you down a different road. People who have a medical restriction that prevents them from being vaccinated, they may be eligible for an exemption to a vaccination requirement. But that's kind of a separate issue. And I wouldn't screen someone out from employment if they tell you that they have a reason why they can't receive the vaccine. But in terms of when you would ask, or when you would reveal to someone that that's a requirement of the workplace, I think doing it in the posting or during the interview process is fine. Okay, so I mentioned earlier, don't ask about salary history. And the reason why I say that is because Connecticut has a law that prohibits asking about salary history. This is something that's relatively new. It was passed in 2018 and became effective in January 1, 2019. What it does is it explicitly prohibits employers from asking an applicant about their wage and salary history, with some limited exceptions, or having someone else ask that person about their history. You can, under the law, ask about what other kind of compensation a person received in their prior positions, health insurance, that sort of thing, but you can't get into the value of those benefits. All right, so why did the General Assembly pass this law? Well, the underlying reasoning was that allowing employers to base initial compensation decisions on what an employee made previously would be a way of perpetuating the effects of past discrimination. This law applies to both private and public sector employers. So, exceptions here, if an applicant discloses the information voluntarily, that's, they've disclosed it, that's okay. If there's a federal or state statute that allows or requires verification of salary history, then obviously that's okay. What we suggest as a way of kind of working with this law is, going into the hiring process, have an idea of what you think the range should be for the position. And then based on the person's qualifications and their experience, that should be kind of roughly where you put the person on the range. So another state law that applies to the hiring process is what's known as the ban the box law. You may have heard about this. This came out a couple of years ago. What this does is it prohibits employers from asking about a prospective employee's prior arrest, criminal charges, or convictions during the initial, on an initial employment application form. There are various exceptions to this. For some positions, it's required by federal or state law. For instance, if someone's going to work in a school, there's exception to this. If someone's going to work in a financial institution, there can be exceptions to this. The intent of this law, is to give people who have been arrested an opportunity to make it through, to be considered on their merits rather than just immediately disqualified based on their criminal history. So the law supplements existing law, which prohibits employers from requiring an employee or prospective employee to disclose the existence of any arrest, criminal charge, or conviction, the records of which have been erased. So if someone has had their records erased, they can lawfully decline to state that they've ever been arrested, criminally charged, or convicted. Job applications that lawfully ask about the criminal history of an applicant must contain a disclosure on this piece about erasure of criminal records. And the next slide is something that you can use for that. I'll show in a second. But again, this law is focused on the initial application stage. Down the road in the hiring process, you can ask questions about criminal history, and you can screen out candidates based on criminal history. But for the initial application, it's prohibited to ask those questions. So if you do ask about criminal history after the initial application stage, you're going to want to have this disclaimer language that addresses the erasure of criminal records. So I won't read this, but this speaks exactly to people who've had their criminal histories erased. And I think I saw a question. Okay, we hire school bus drivers on an established pay scale based on years of service. We will match a licensed driver from another company with their current top to our closest rate in our pay scale. Once we offer them a position, we ask them to provide proof pay stub of rate of pay so that we can hire the person at a higher rate rather than at the lowest rate. Is this something that we should be concerned with? Well, I think, yeah, I would be somewhat concerned about that if you are asking candidates during the interview process, during the application process, what their salary history has been. And if you're making determinations of what the person's salary should be based on their past rate of pay, I think that could be problematic based on this statute. I don't think there's an exception for school bus drivers, but that it's possible there is an exception. I would kind of need to check with that, but to me, I have some reservations about that practice. Okay, so along a similar lines, Connecticut also has a law on the use of credit histories in the employment process. And that law, 3151 TT, prohibits employers from inquiring about an applicant or an existing employee's credit history except in limited situations. This statute lays out permissible situations and exceptions. And here the exceptions are, if the person works in a financial or fiduciary capacity in a managerial position that involves the control of the business, then you can ask about credit. You can run a credit check. If the person has access to a customer's or employee's personal or financial information, you can run a credit check. If the person has an expense account or corporate debit or credit card, you can run a credit check. Same for access to confidential or proprietary business information, or if the person has access to non-financial assets valued at $2,500 or more. Each credit check that happens without one of these exceptions applying is an automatic violation that results in a $300 penalty for each inquiry. So this is something that you really you want to stay away from. Just looking at another question, we perform background checks. If the report contains arrest, then we ask for an explanation. Comes back from the company flag. Is there certain language we should or shouldn't use? Well, that kind of, thanks for that question. That sort of ties into my next slide with the background check process. And let me just get to that now. So along with the state law, there's also a federal law, the Fair Credit Reporting Act, that provides that an employer must disclose to a job candidate that it will obtain a background check on the candidate at the time of the application. So, if you're looking at arrest records as part of your application process, you're going to need to disclose that you're going to run background checks as part of that process. Your initial employment application form shouldn't have a box that people would check off for their criminal histories, but if you're having a background check, you would disclose that. You need to obtain the employee's consent to run the background check. And when you furnish the information to the company that's running your background check, you need to certify certain facts to that company. This kind of relates to your question. If an employer decides not to hire an applicant based on the information obtained in a background check, the employer must tell the applicant he or she was rejected because of information in the report and must provide the employee with a background check report and a summary of the employee's rights. So I'm just looking for the chat, the question again. I'm having a little bit of difficulty accessing the chat. Well, next time I see another question,
If I can jump on and just ask you.
Oh, that's great.
I thought that would be easier for you, Zach.
Yeah.
Instead of struggling.
Appreciate it.
So we do background checks.
Okay.
And we had one candidate come back that, was flagged red, basically saying by the company that she had an extensive arrest record. And what we decided to do was speak to her about it. And she provided a statement, and we did, override the background check once the explanation was given in writing. And we put it obviously in her file. Is there certain language in that process that we should or shouldn't be using when we go to the candidate and say that the background check was flagged?
Yeah, I don't think under any of these statutes there's any specific, magic words that you need to give to the person in order to have them provide a response. I think you would want to phrase it in such a way that you're not accusing them of actually having, committed whatever. But I would say, in accordance with the law, as you know, we ran a background check, which you consented to. That background check indicated that you were convicted of such and such on such and such date. If you would like to respond to this information, please provide a written response to whoever your human resources person, and then keeping that on file, I think is fine. I don't think there's any magic words for that, but I think you should be consistent whenever this happens with employees so that you're following the same practice.
All right, great. Thank you so much.
Sure. Okay, so, a related topic, drug testing. Connecticut does have a law that allows employers to perform drug tests both at the outset during the hiring process and while an employee is employed. This statute applies to all private sector employers and nonprofits, but it does not apply to the state or political subdivisions, which are towns, boards of education, etc. So what does this law provide? Well, it allows employers to do a pre-employment urine test for alcohol and drugs so long as the applicant consents in writing to the drug test at the time of the application. Secondly, as long as the drug test is conducting using a reliable methodology, and if there's an initial positive, that positive has to be confirmed by a second test, which uses I guess it's called chromatography and mass spectrometry methodology. And if those tests confirm the positive, then the prospective employee needs to be given a copy of any positive test result. So once you get those test results back, you as an employer, you need to keep those records confidential, and you should be keeping them in the medical file of an employee for negative tests. And if you hire someone despite a positive test, keep that in the medical file. For public sector employers, there really isn't a law that's similar to the state law I just mentioned. It really depends on the position. There may be specific federal or state laws that apply to the position. For the bus company, I'm sure the Department of Transportation has restrictions that apply to drug testing. Also, if you have unionized employees, you may have a collective bargaining agreement provision that talks about drug testing. So I mentioned this a moment ago, but no federal law that applies generally to drug testing. The DOT has transportation specific restrictions for safety sensitive positions, and there are different rules that apply for tests before employment, tests based on reasonable suspicion, random tests, when an employee can return after a positive test, etc. There are also laws that apply to certain other industries, people who work in the nuclear industry, defense industry, NASA, that sort of thing. Federal grant recipients may be subject to the Drug-Free Workplace Act. And if an employer is subject to that law, they need to have a written anti-drug policy in place, and need to make good faith efforts to maintain a drug-free workplace. Testing isn't necessarily required by that, but it's not prohibited either. So an interesting issue on the drug testing piece is the tie-in with the Americans with Disabilities Act. And so under the ADA, someone who is a recovering alcoholic or recovering drug user may be considered disabled under the ADA, which means that it's illegal to discriminate against someone based on their disability status as an alcoholic or a recovering drug user. So, with the ADA in mind, if someone has a past history of drug use or a past history of alcoholism, refusing to hire someone on that basis alone could be problematic, and that could be viewed as disability discrimination. Like other types of disability, the focus should really be on whether or not the employee, who may be a recovering drug addict or a recovering alcoholic, whether or not they can perform the essential functions of the job. If they can't perform those functions, due to their addiction or due to their alcoholism, then that is not protected, obviously. And someone who shows up to work high or drunk, you can terminate that person, even if that person has a history of seeking to, trying to recover from drug or alcohol addiction. So, our best practice recommendations with drug and alcohol testing, make sure your testing policy is up to date. Make sure you are testing as permitted by law. Train your management and supervisors to follow the law. I think with drug testing, especially, that's a topic where you really want to have your systems down pat, and not something that you want to kind of fly off the cuff with how you manage that process. Okay, hiring letters. So before I get into this subject, I don't know if anyone has any quick questions before we move on. No? Okay. All right, so, I think a lot of employers don't realize this, but you are legally obligated to provide certain information to every new hire upon hire. And this is a statute, Connecticut General Statute 3171F, that requires that you as an employer memorialize basically what the terms and conditions of an employee's employment are going to be at the outset of employment. So the things that you have to provide, rate of remuneration. So, what is the person's hourly or weekly wage or salary? How often is the person going to be paid? Is it on a weekly basis, or is it on a bi-weekly basis? If you're paying someone on a bi-weekly basis, by the way, generally you need an exemption from the Department of Labor in order to pay on a bi-weekly basis. Hours of employment, what shift is the person going to work? Also various other things. What is your policy on vacation pay, sick leave, health insurance? Those things should be set out in writing in a hiring letter in order to comply with this statute. If I was talking to an employer last week who hasn't been doing this, and so what happens if you don't do this? Well, you don't go to jail. There's not a fine or a penalty. However, if you don't do it, this could be problematic, because if there's ever a dispute about what the person was hired to do or what the person's rate of pay was, without this kind of letter, it's their word against yours. And if you could think that someone may say, well, during the application, during the interview, I was told it was going to be paid $20 an hour. And if what you really meant was for that person to be paid $18.50 an hour, if you don't have a letter that memorializes that, it's your word against theirs. So having this is just the best practice, and it complies with the law. Here are other details to include in the letter. The statement here is very important. Having a statement that the company has discretion to change conditions of employment during the course of employment. You want to make that very clear. Otherwise, there could be a claim that an employee has a contractual entitlement to their position. You also want to say that the terms of the letter supersede any prior oral or written agreements. So an oral, something that was said during the interview process, something like that. And you also want to say that nothing changes need to be made in writing. So with this letter, you can say things like the offer of employment is contingent upon the employee providing verification of their ability to perform the job with I-9 checks, that sort of thing. They're passing a reference check, background check, drug test if applicable, and then this next one I think is very important, but if the employee is going to be at will, you want to absolutely make that clear that in this hiring letter that the employee is hired on an at-will basis and does not have a contractual entitlement to employment. You should have a signature line for employees to sign and acknowledge receipt that they've received this letter. So, many employers have handbooks, and handbooks are a great idea. What we recommend is really to use these hiring letters in conjunction with your handbooks, and you would also, with your handbooks, typically have a very prominent at-will disclaimer, along with a signature line for the employee to use to sign and acknowledge receipt, and when they received, the hiring letter and or the handbook, if you have a handbook. A few additional things to consider adding. You want to, especially if someone is coming from a situation where they may have had a non-compete in a prior position, it would be a good idea to have someone commit that they're not violating any agreement entered into prior to their starting with the company. You would want to add maybe something that says that an employer does not seek disclosure of confidential information from an employee's past employers. You may want to have something saying that an employee promises not to disclose confidential information that the employer acquires through their position. And if you're going to have a non-compete or non-solicit covenant, you'd want to have that committed somewhere in a document that will kind of go along with the hiring letter. And non-competes and non-solicits are kind of outside of the scope of this presentation, but that's something to really think about during the hiring process if you need a non-compete or non-solicit. And if you do, you definitely want to set it out during the hiring process. Okay, so what not to include in a hiring letter? So these tie back to the at-will issue, but references that employment is for a definite period of time, unless that's actually what you want. Any kind of statements that the employee has job security that goes beyond at will, unless that's what you want. And any kind of representation that termination needs to be for just cause or something like that, which we're going to talk about more later. Okay, before I move on to discipline, termination, and layoff, I don't know if anyone has any other questions. I can't see the chat. Oh, here's the chat. All right, back on the drug testing. What if an employee has a medical card for marijuana use? So if they do have a medical card for marijuana use, that use of medicinal marijuana is legal in Connecticut. So unless you are in certain designated safety sensitive industries, generally filtering someone out based on their use of medicinal marijuana would be problematic, and is not generally a permissible basis to screen someone out from employment. Okay, any other questions before I move on? And if people want to just say them out loud, I'm fine with that too. No? Okay. So employee discipline, termination, and layoff. So I've talked about this several times before, but really the starting point to think about with hiring employees is employment at will. And this employment at will is kind of the default setting for Connecticut employment. And what it means is that an employee is employed for an indefinite period of time, an indefinite term, and that they can be terminated for any reason, meaning a good reason, a bad reason, any reason, as long as it's not an illegal reason. And we'll talk about what that means in a second. On the flip side of that, if an employee is at will, they can quit at any time for any reason, with or without notice. So if an employee is at will, there's no requirement that you have just cause or that the employee commit willful misconduct in order to discipline them or terminate them. They serve at will, which is basically at your pleasure. And if you feel that this employee is not living up to your expectations or has committed something, engaged in conduct that you just don't like and you think you can find a better employee, you can terminate them. With that said, disciplinary termination cannot be for an illegal reason. So what would be an illegal reason? Well, discriminating on the basis of protected class. We talked about what protected classes are. If you terminate someone because they are Hispanic or a woman, that's illegal, even if the employee serves on an at-will basis. Retaliation for constitutionally protected speech or whistleblowing activity. Connecticut has a statute 3151Q that protects employees from engaging in protected speech from being terminated for that speech. So if someone writes a letter to the local editor of the paper saying, I love Donald Trump, or I love Joe Biden, and you don't like that, and you terminate that person because of that, that would be illegal, even if the person is an employee at will. Whistleblowing activities. So if you work in a safety sensitive position, for instance, and someone feels that, they notice that, the buses aren't being maintained in terms of a regularly mandated schedule, and they report that to a superior, and the person is fired as a result, that could be a problem even if the employee is at will. So, I mentioned this kind of concept earlier, but even in the absence of an explicit written contract, Connecticut courts have found that there can be an implied contract based on words, actions, or conduct of the parties. So for instance, if during the interview process you say, well, we only, you can expect to work here as long as you don't commit a serious rule violation. That's the type of thing that could be argued to change the relationship from at will to something more like a traditional contract of employment. So you need to be very careful about the representations that you make to employees in things like the hiring letter, in your handbook, and even what you orally tell an employee. So, again, the hire letter, handbooks, employer policies, benefit plan documents or descriptions, emails, all of these things, when you're dealing with employees, you just need to be careful not to go beyond the at-will relationship unless that's something that you actually want to do. And there are court decisions that talk about, well, the manager said this in an email and the employee relied on that. Therefore, this isn't a strict at-will relationship. Just, a last thing to touch on here, consider the timing. If an employee received a document that forms the basis of an implied contract, if they got that document after commencing employment, it's probably not going to be the basis of a claim that there's a contractual relationship beyond at will. However, if during the hiring process, again, an email to the prospective employee saying, we will, you're going to have a guaranteed position with us for at least a year. If there's an email saying that, you're going to have a hard time defending yourself when you terminate the person after 6 months for poor performance, and you say that the person was at will. Okay, so dealing with problem employees and discipline. So some of this, this is common sense too, and there is no prototype problem employee. I think every manager at some point in their career deals with someone who falls into one of these categories. Just a poor performer, can't live up to the job description or job expectations. Someone who's difficult to deal with, just not a team player, doesn't get along with coworkers. Someone who also means well and is trying to do the job, but just never quite gets it and doesn't live up to expectations. So how do you deal with these people? Well, number one, you don't hire them in the first place. The most prevention is an ounce of prevention is worth a pound of cure. Carefully and thoroughly checking references is the best way to avoid having a problem employee, and having a good interview process and a good selection process in place. Hopefully that screens out people who are not going to be able to do the job. You get what you tolerate. So this is something that I think, we as attorneys in the employment law field, we sort of get this issue all the time. And we hear from our clients about how, this person they were never a good performer. They've had all these issues, but then we ask for the personnel file and there's nothing in there. Nothing was ever documented, and they even got good reviews. And then when it comes, when there's a lawsuit where the person claims that they were terminated because of their gender or race or what have you, and we say, well, no, this person was a terrible performer, we have a hard time proving that because there's no documentation to support it. So, you get what you tolerate. And when you tolerate a poor performer, you have a hard time proving to the outside world that person really wasn't a good performer. So, here I'm sort of talking about the difference between misconduct and just poor performance. A person who's not performing, it could be an issue where the person is breaking the rules, or it could just be a lack of employee. Employees who are unwilling to perform have conduct issues. Employees who are unable to perform have performance and ability issues. I mentioned this earlier, but documentation is everything when it comes to personal actions. Again, it's the way to avoid legal exposure. It's a way to, if you want to correct the employee, if you want this employee to get better, putting things in writing so they're aware of their performance deficiencies, and so that you can explain to them how to correct their conduct is huge. Having the documentation, it's, again, something for the outside world. If there's ever litigation or dispute or a claim with the CHRO, for instance, it's your evidence, it's your exhibit A that there were in fact performance issues, and that the employee knew that their performance was unacceptable. Again, if you don't have that, how do you prove that? It's your word against theirs. And when it comes time to litigation or CHRO complaint, you as the employer, you have an interest in defending your action. So without the documentation, whoever the fact finder is going to take what you say with a grain of salt. Having the documentation, it's almost like a third party. It's objective, and you can prove that there were issues. All right, so what should your documentation kind of look like? Well, one thing to think about is we absolutely recommend documenting performance issues, but with that being said, there's a danger in just having kind of form notices of disciplinary action. Generally, you want to make any kind of discipline that you issue, you want it to read so that someone from the outside could read the document and understand what happened and get context. So, the date, the time of the incident, witnesses to the incident, what the conduct was, for written warnings, for suspensions, maybe talking about how the conduct should be corrected in the future. Generally, you don't want to have a time limitation for improvement in performance, because that works both ways, and it could lock you in to having a poor performer for maybe longer than you want to have that person. Being as thorough as necessary is, from our perspective, a very good idea. I think more detail is better than less. And again, avoiding promises and words that create false expectations. If you have a collective bargaining agreement, then that is going to govern discipline, and you certainly want to comply with it. If you have a collective bargaining agreement or not, you still want to comply with all laws that address performance and discipline. So under our State Personnel Files Act, there's an obligation to provide an employee who receives a performance evaluation or written discipline. They should be advised in writing that they have the right to seek removal of that document from the personnel file or to rebut the document. There's a question here. When it comes to writing an employee up, they are performing their job, but are negative, spreading rumors, problematic attitude, doesn't clean up after themselves, not a team player. Can I write them up? And if so, how? Well, if the employee is at will, you can fire that person. And, or if you don't want to go that far, if you want to give them a chance to improve their performance, you can write them up too. What I would do in either case is I would do a letter, and I think you would want to give kind of almost like a newspaper article, the facts that what negative attitude, how has that been seen? What's the evidence of the negative attitude? Spreading rumors, what do you know as a fact that they said that was false, that was maybe defamatory? Not cleaning up after themselves. When did that happen? Who witnessed it? How many times did it happen? I would spell out all that, in a document, and then produce the document to the employee. And that's pretty much how you would do it. Okay, so effective discipline. Discipline is, serves multiple purposes. If you want to have the person as a long-term employee, effective discipline is something that's going to enable the person to improve their performance. Oftentimes a person, they might not know that what they're doing is problematic. So, maybe it makes sense to give a written warning letter that explains why what they're doing is problematic and how they can correct it. So discipline doesn't have to be a negative; it can also be a positive. Discipline should be reasonable and not arbitrary or capricious. What I mean by that is, there should be some general consistency in terms of disciplinary responses to issues. So if one person is late and they get a written warning, and then another person is late and they get a 5-day unpaid suspension. There should be some reason that would explain the difference. If there's not a reason, then generally your discipline should be consistent. So the just cause standard, this is something that for those of you that manage a unionized workforce, you've probably seen this or you're familiar with this, but many collective bargaining agreements have language saying that discipline needs to be supported by just cause. And what that means is often a subject of debate. And unions generally advocate for a 7-factor test to determine if discipline is supported by just cause. So the factors are warning. Did the employee have warning that their conduct was prohibited? Reasonable rule. Is the rule that was allegedly violated reasonable? Investigation. Was the alleged incident investigated? The other factors. Was the investigation fair and objective? What did the investigation conclude? Is the proposed punishment in line with what the outcome of the investigation was? Fair application of the rules. Has the workplace rule at issue been applied fairly and even-handedly in the past? Lastly, does the punishment fit the crime? Again, with that one, really thinking about consistency. If there was a very similar incident and someone got lesser discipline, why in this case is someone getting more severe discipline? Contracts, collective bargaining agreements that have just cause, typically an independent arbitrator hears the case and decides whether or not the discipline is supported by just cause. So a question on this: what if an employee chooses not to sign a performance disciplinary action plan memo? Well, if they absolutely refuse to sign that, or if they refuse to sign a statement saying that they acknowledge receipt of that, then what I would do is, as a manager, I would put a note to the file saying on such and such time or such and such date, this person was provided with a copy of their written warning, suspension letter, what have you. The person refused to sign the document, and then I would put that in the file along with the document so that you have a paper record that the person actually was presented with the document. Progressive discipline. So this is a concept you may have heard of, and the basic idea is that generally speaking, you want to elevate the disciplinary reaction based on each successive infraction of a rule. And the typical sequence for progressive discipline is, you start with a verbal counseling. If that doesn't work, you go to a written warning. If that doesn't work, a short-term unpaid suspension. If that doesn't work, a long-term unpaid suspension, and finally termination. So an advantage of using progressive discipline is it helps have uniformity across the workforce. So, when someone's late, if everyone, first gets a written warning, then it's followed by a 2-day suspension, what have you. That's useful because you can avoid claims of discrimination or favoritism by having that sequence of events in place. It's also useful because you're giving the employee the opportunity to improve their conduct, and you're making it clear to them what's expected, and they know that if there's a subsequent infraction, what the result is going to be. The disadvantage, and I highly recommend avoiding any kind of language in a handbook or hire letter or whatever that creates a lockstep progressive discipline pattern. But the disadvantage is that if you have lockstep progressive discipline, meaning in all cases it's first a verbal counseling, second a written warning, you're limiting yourself. And if someone commits a serious infraction, you know, you don't want that person around anymore. And you should be able to respond with a more severe disciplinary consequence if that's warranted. If someone steals on the job, you know, I don't think that ever should be a written warning. I think that should be an immediate termination. So you don't want to lock yourself in to progressive discipline that would provide just for a written warning or what have you. Another question, do you have a general opinion of last chance agreements as an added step or replacement step to long-term suspension, progressive discipline? So, you know, we use last chance agreements kind of all the time in unionized settings because there is this just cause protection, and we want, in exchange for the last chance, to have people waive their rights to to file a grievance and to seek arbitration for you know, just cause discipline. I think if you're in an at-will environment, you know, I guess I would question why you want to, you know, what's motivating you to give that person that last chance. Because if you're really in an at-will environment, you're not obligated to give the person the last chance, and it might not be something that you want to pursue. Another question here, we have an employee with constant call outs. I told him that if it continues, I would cut his hours. Cutting his hours will lose him his health insurance. Is this legal? So that question kind of touches upon the ACA, the American Affordable Care Act, Obamacare requirements with respect to providing health insurance to full-time employees. If the employee is at will, then generally you have the ability to offer them, you know, reduced hours or termination. And if they want to go with reduced hours and it will result in them losing their health insurance, you know, I don't have an issue with that from an at-will perspective. However, what I would say is that, you know, COBRA rules, which allow individuals to continue health insurance for a period of time after they've lost eligibility, may apply. So you want to be very aware of that. So, you know, just some best practices with discipline. You want to be consistent. You know, you want to set standards that can be maintained and have consistency across the workforce with those standards. We've talked about this before, but be very careful of what you say. Don't make promises that you cannot or will not keep, in terms of, especially in an employee keeping their job, you know, if they improve their performance, that sort of thing. Be decisive. You know, someone has to make the hard decisions, and, you know, facing termination, that kind of thing, is very difficult, but what's the alternative? Do you want to keep a poor performer around for years and years just because of the difficulty of termination? What's better for the organization? All right, I know we're running a little bit short on time, so I'll just quickly talk about termination. So I've talked about this before, but, you know, the golden rule of discipline and termination is, you know, put it in writing. If it's not in writing, there have been studies that say juries don't believe you. So, you know, to protect yourself legally, it's always better to put it in writing. Otherwise, it's just your word against theirs. This is something I talked about before, same idea with disciplinary letters, but you want to lay out the facts, identify what exactly happened, what the infraction was, if the person is given multiple opportunities to improve their performance, lay out, on such and such a date, you were issued a written warning for your tardiness. On such and such date, you were issued a suspension for your tardiness. Notwithstanding those disciplinary actions, you have failed to improve your performance. Laying all that out is very helpful, because the termination letter, if someone sues or files for unemployment, what have you, that's Exhibit A. And you want to have the sequence so someone from the outside looking in can see exactly what happened. Never give a reason that is false or inaccurate. You don't want to give too much information. You don't want to give too little information. You shouldn't terminate someone if that termination violates your company practice or policy, for instance, a whistleblower, that type of thing. High risk termination factors. When an employee has been around for a long time, that's more sensitive. If an employee has a history of claims against the company, that can be sensitive. If an employee is on a leave of absence, that can get tricky and sensitive. And if an employee has recently complained, that means they may have an issue. Termination checklist. Maybe I'll stop after this. Final pay is due no later than the next business day succeeding the date of discharge, so you should have that ready. Benefits, pension, 401k, you'll want to review your policies and your plans to see what kind of eligibility issues there may be. Vacation pay, sick pay. If you have a policy providing for payout of vacation pay or sick pay upon termination, that should be included in the final check and itemized. Health insurance, the person may have eligibility through COBRA for continued insurance, and likely will have eligibility through COBRA. Unemployment, we haven't really talked about unemployment much, but if the employee has committed willful misconduct, which can mean a number of things, but generally violation of an established work rule, they may not be eligible for unemployment. So you should not say to them during the termination meeting, we won't contest unemployment or something like that. So, with that, I think we're almost out of time. I don't know if there are questions or how we should leave it. Danielle or Joanna, I don't know if.
Does anyone have any questions for Zach? Okay, well, thank you so much, Zach. Lori, do you have a question? Okay. Thank you so much, Zach. I will be sending out the slideshow to everyone in an email, and I hope everyone has a wonderful day.
Okay. Thank you.
Thank you.
Thank you.
Have a good day, guys.
Bye.